This is an episode of Scott Talks Law. Welcome once again to another episode of Scott Talks Law. So, in this episode, we'll be talking about dissolution of marriage. So, this is family law, and dissolution of marriage is that ending of a marriage relationship, breakdown of a marriage relationship, termination, and just bringing to an end of a marriage relationship, is dissolution of a marriage. So, I've got the grounds for dissolution. We're going to look at them. You've got factors of dissolution or divorce. You've got theories that explain about dissolution. You've got consent theory. You've got fault theory. You've got breakdown theory. And according to these theories of divorce, the fault theory says that dissolution occurs because of the fault of the other spouse. So it is the fault of the other spouse, the act of adultery that caused the other, the innocent party to claim the divorce, the fault. Like you can just show out the fault for this theory to apply, and this theory mostly applies in Kenya. So the fault of the other spouse to must have resulted to a divorce. So this theory is mostly applied in Kenya. That's why you find that those grounds for cruelty, adultery, um, depravity, desertion are usually brought out in claims for divorce under Kenyan law, mental insanity. So under this fault theory, must bring out the it is dependent on the fault of the other spouse. So another theory is the consent theory, and the consent must be there for dissolution to occur or the marriage to end. And the other theory is the breakdown theory. This whereby that relationship just comes to an end. And consent theory is based on the fidelity, mutual fidelity, and the breakdown theory is whereby public or private interest is not important, where parties feel like they want to end a marriage relationship. So in we are going to look at the grounds for dissolution of marriage, and we are also going to look at we are going to look at these grounds. So the first ground is the ground of adultery. So we've got grounds for dissolution of marriage. These are adultery, cruel treatment or cruelty, the ground of desertion, the grounds of is unsound mind, and under unsound mind, you must be able to show that this mental disorder is incurable. Disorders that can be cured that cannot result to grounds for dissolution or bringing the marriage to an end. So we have conditions like schizophrenia, which only lasts for a particular time. They cannot be considered as grounds for to dissolve a particular marriage relationship. We also have depravity as a ground for marriage dissolution and exceptional depravity. So adultery means consensual sexual intercourse during the substance of the marriage relationship between one spouse and the spouse of the opposite sex not being their spouse. So this is whereby you have spouse who have been in approved marriage, a marriage relationship that can be proved. So one spouse um, involuntarily goes and commits sexual intercourse with someone who is not within their spouse. So when he or she does that act, then is considered to have he or she is considered to have committed adultery. And you must note that this adultery, an act of adultery, must be involuntary. So you have circumstances whereby a spouse is just raped, then you cannot claim that adultery is there on those bases. So for you to prove adultery, there must be penetration, and penetration is not a must, that there must be even some amount of penetration, some small amount of penetration can be considered as is considered to as penetration. So in the case of Rajesh Kumar Singh SIGN versus Rekha Singh, the 2005 case is whereby a woman was raped and the husband was not able to obtain divorce on those grounds. So Penetration must be there for adultery to occur. Penetration must not be complete, but not complete penetration, as it was said in the case of Dennis versus Dennis, late 1905. So, in the case of Wangari Maathai versus Mwanga Maathai 1980, the charge must be proved clearly beyond establishing a mere balance of probability or a proponents of probability or mere suspicion and opportunity to commit adultery. So a claim of adultery must be proved beyond reasonable doubt. So another ground for marriage breakdown or marriage dissolution is the ground of cruelty. And cruelty, this is whereby the other spouse is able to apprehend the acts of threat. This cruelty must be weighty, and this cruelty include acts that threaten health, acts that threaten limb, the acts that threaten life of the other spouse. So the other spouse feel like is able to uh, feel like this situation within this marriage relationship is unbearable, then he can claim for an act for divorce under cruelty. So if he or she is able to apprehend those acts of cruelty, then he'll go and be granted divorce. So in Gollis versus Gollis 1963, and Williams versus Williams, which establishes that the balance in claims of cruelty as a ground for dissolution of the marriage was in favor of giving relief to a complainant in situations which has become intolerable, such that the spouse caused injury to the complainant's health and is likely to do so will amount to cruelty in the grave. Will amount to cruelty if it is grave and weighty and decide that the petitioner cannot reasonably be expected to put up with or tolerate with it. So this act must be grave and weighty, and that the petitioner is not able to put up with the act. So in Colorado, so such as Newbold in Colorossi versus Cologrossi in 1965, it was said that there's no comprehensive definition of cruelty has ever uh, been accepted as satisfactory. Much depends on the habits and circumstances of the matrimonial life and the husband and wife and their character and the mode of conduct of each other, knowingly to each other, and the true intentions and feelings of each other. So, according to such as Newbold in Colorossi versus Cologrossi, there is no certain measure of cruelty, but it depends on the relationship, per se, the conduct and the character of these couples. So, he brought out essential elements that must be showed to prove the act of cruelty, and this essential element of the petitioner is based must so the petitioner seeking for act of cruelty must be able to show that the, the relief must be proof of actual or probable injury to the life, limb, or health of that petitioner. So a decree is not granted on a single act. So you must be able to show that there was threat to life, threat to injury of your head, life, and limb. So Justice Chesoni categorized cruelty into four elements in the case of DM versus JM 2008. So the first one, there must be the misconduct must be grave and weighty in nature. The second one, the misconduct must be caused by the respondent or the respondent acts of cruelty, the one that caused that apprehension. The third one, there must be evidence of the conduct that amounted to cruelty and the injury was caused by the misconduct of the respondent but not any other person. So there must be a the misconduct must be weighty in nature. This misconduct must have affected the health and or must have injured the plaintiff. And the third one, that the whole evidence of the conduct must have amounted to cruelty in the ordinary senses. and the injury was caused by the impact of the respondent. So the fourth element that were brought up by Justice Tesoni is that the misconduct must be weight in nature. The misconduct must have been caused by the respondent's acts. There must be apprehension of a threat to life or health, and there must be evidence that is the respondent who actually caused that misconduct, but not any other person. So let us look at the case laws. We have the case of Ngerechi versus Marindani 2004. A divorce was granted on account that the husband was using abusive and obscene language in public towards the wife, causing her psychological trauma or torment. So when you just abuse your wife, you're causing him not only physical but also psychological trauma. Divorce can be granted on those grounds. You also have the case of Mercy Wanjiku versus Job Kangwomo. A divorce was granted on account of cruelty in form of physical and mental violence. And Rosbella, in the case of Rosbella Odhiambo Mondi versus Daniel Michael Owiti, this is whereby the husband used to threaten the wife in public and private places, threatening to kill the wife because the wife could not give birth. So the husband used to say that this wife was useless and that he used to give subject her to psychological threat, physical threat, and this wife was able to apprehend those manner of threats. So a divorce was granted on those grounds, and the court also viewed the decision in the case of Mimi versus Mimi, and that cruelty was defined as willful and justifiable conduct, and such character as to cruelty must cause danger to the life, limb, or health, bodily or mental harm to give rise to a reasonable appreciation of such danger. So yeah, the court considered the decision in Meme versus Meme that the act of cruelty must be weighty in nature. This act must be able to cause, must affect the health, limb, and life of the respondent, and also affect physical and psychological, must have that physical and psychological effect. So another ground is exceptional depravity, and this is whereby the ordaining LJ as then was provided an restrictive guidelines on the subject in the English case of Bowman versus Bowman. So according to Lord Denning LJ, the only grounds to be considered are the ones of cruelty and adultery within 3 years of marriage relationship. But after 3 years of a marriage relationship, then exceptional depravity can also be considered as a ground to grant dissolution. Why should you be deprived within just for like all 3 years? It is not reasonable, according to the Denny LJ in that case of Bowman versus Bowman. So we also have circumstances that a man can be exceptionally deprived when this man is adulterous, commits adultery maybe with the sister of the wife, commits adultery with the servants of the wife, then he can be denied conjugal rights. Like why should you be not be deprived when you're doing those kind of things? And when the man is also committing other offenses within the marriages, when the man is cruel, when the man is just committing other offenses like that cause injury or violence to the wife. So another ground of dissolution is desertion. And desertion is whereby someone just abandons the marriage relationship, someone leaves a marriage relationship, shuns away from a marriage relationship, then you say he or she has deserted that marriage relationship or matrimonial home. So, so it is the unjustified withdrawal from the matrimonial home of state, and it's a state of affairs through which one spouse has virtually given up his or her matrimonial relationship with the other. So desertion is not a single act complete in itself, it's a continuous course of action to be determined in order of facts and circumstances of each case. So two essential elements must be determined: the fact that causes desertion and the intention to bring cohabitation permanently to an end. What is it that is causing you just to leave your matrimonial home? You must be able to bring out clearly the reason and it must also bring out the intention to like cause that distortion. So we also have few sexual elements that must be considered in the deserted spouse, and the absence of consent and the absence of condition giving reasonable rights to the spouse living. So we also have the ground of unsound mind, and unsound mind must be incurable. Not all mental conditions are considered as grounds for marriage dissolution. So SMT Rita Roy versus Site Chandra Dendra Roy, it was said that it is only incurable mental disorders which renders husband and wife unfit to lead the matrimonial bond. So it was also bars to divorce, and these are connivance and condonation. Connivance is whereby you are consented for adultery. So you cannot, the court cannot defend you when you are consented for adultery to be committed. So discretionary bans are the ones of unreasonable delay and petitioners uh, petitioners on adultery. So keep in touch, you're going to learn more and look at more case laws in marriage law and family law, and